Suppose there was a passenger on that train, and when the train was derailed, the passenger sustained an injury. And suppose the passenger brought a lawsuit against me, saying that my negligence in damaging the railroad tracks was a cause of that passenger's injury. The only question we'd really have to resolve in that case, because we know that I was negligent, and we know that my negligence was an actual cause of harm that we know occurred, the only question remaining would be whether my negligence was a legal cause of the harm. And once again, we turn to our three arguments: foreseeability, probability, not extraordinary in retrospect, and we just ask those questions. Was the injury sustained by the passenger a foreseeable result of my negligence in tearing up the railroad tracks? It sounds like an easy enough question, except it's slightly complicated by the fact that there was another cause of harm. Sure, my negligence was a cause of harm, but there was another cause of harm, and that other cause was the train driver's negligence. Remember, we said the train driver wasn't looking where he was going. He was reading a paperback novel instead of looking where he was going. And if he had been looking where he was going, he would have seen the torn up railroad tracks. He would have stopped the train in time to avoid the accident. What we're faced with now is a problem involving an intervening cause. Remember now, this is a lawsuit by the passenger against Fins, the guy that tore up the railroad tracks. And what we're looking at now is a problem involving an intervening cause. Intervene simply means to come between. An intervening cause is an additional cause of harm that came between the defendant's conduct and the plaintiff's injury. In this case, the defendant, Fins, tore up the railroad tracks. The plaintiff sustained an injury when the train was derailed, but there was an intervening cause of that injury, and the intervening cause was the train driver's negligence. If the train driver had been looking where he'd been going, this thing would not have happened. And so the train driver's negligence was a cause of harm. Since it came along after Fins' negligence, but before the injury, it came between Fins' negligence and the injury, so it's an intervening cause of harm. My goodness, does that make the problem a whole lot more complicated? Well, to hear some of your fellow students talking about it in the classroom, you would certainly think so. But I tell you that it doesn't make the problem a whole lot more complicated, not if you keep your eye on the ball. And by the ball, I mean those three arguments that we talked about, which are really just three ways of stating one argument. Defendant's conduct is a legal cause of harm if it was an actual cause of harm and the harm was a foreseeable result, or the harm was a probable result, or the harm was not an extraordinary result in retrospect. What are we looking at here? Fins tore up the railroad tracks. A train came along and was derailed. The train would not have been derailed were it not for the intervening cause. In deciding whether Fins' conduct was a legal cause of the harm, all we have to do is ask whether the intervening cause was foreseeable, or was probable, or was not extraordinary in retrospect. And remember, it's not enough to state a conclusion. You've got to make an argument, because. So let's hear an argument for the plaintiff. Fins was negligent, the plaintiff says, and that was a given when we got the problem, so we're not even going to argue about that. Fins' conduct was a factual cause of harm because if Fins hadn't torn up the railroad tracks, the train would not have been derailed. Of course, the train would still not have been derailed if the driver of the train had been looking where he was going instead of reading a novel. We now have to decide whether the driver's intervention, that intervening cause, was foreseeable. Driving a train is a very boring occupation. After all, the driver doesn't even get to steer. And he only stops when he gets a message from the station telling him to stop, and he only goes when he gets a message from the station telling him to go, and most of the time, he just sits there with very little to do. Under those circumstances, probably or foreseeably, drivers will attempt to amuse themselves any way they can. It's not unlikely that they would do so by reading a book. Therefore, the driver's intervention of reading a book instead of looking was foreseeable was probable, was not extraordinary. And that means the derailment was foreseeable or probable and not extraordinary. So, Finns' conduct was a legal cause of the derailment. Notice when we... And that means Finns is liable. This is very important to consider. When we're trying to decide whether Finns' conduct was a legal cause of the derailment, we talked about what the driver did, but we really don't care about whether the driver was negligent, whether the driver acted reasonably, whether the driver is liable for the harm. All we care about is whether the driver's conduct, that intervening cause, was foreseeable, was probable, was not extraordinary. If we conclude that as we have done, that the driver's conduct was foreseeable, was probable, was not extraordinary, then we call that intervention a concurring intervening cause. And the bottom line is, it doesn't get Finns off the hook. Of course, an argument could be made on behalf of Finns that would go this way. Driving a train places a very important responsibility on the shoulders of the driver, who must be aware that if he or she makes a mistake, many lives are at stake and a great deal of property is at stake. And so it's really unlikely that a driver who knows that he or she has been entrusted with that responsibility would do something as irresponsible as read a book while driving instead of looking where he or she is going. Therefore, the driver's conduct was unforeseeable. That intervening cause was unforeseeable, was not probable, was extraordinary in retrospect, and that makes the train wreck unforeseeable or not probable or extraordinary in retrospect, and Finns is not liable for it. Then we say the driver's conduct was a superseding cause of harm. But remember, none of that really depends on whether the driver was negligent or whether the driver acted reasonably or whether the driver was liable, because we're considering the liability of Finns, the first defendant who acted. Now let's expand that hypo a little more, and let's say that the passenger sues the driver. Now, was the driver negligent? Well, we can make arguments about, certainly the driver owed a duty to passengers on the train. That duty would be determined by the relationship of driver to passenger. And the chances are that it was unreasonable for the driver to read when he should have been looking where he was going, so let's say the driver was negligent. The driver's negligence was an actual cause of harm because we know that the accident would not have happened if the driver had been looking where he was going. The only remaining question is whether the driver's conduct was a legal cause of harm. Now, here's where some of your colleagues who haven't had the benefit of this tape are going to be confused. They're going to think that the damaged railroad tracks were an intervening cause of this harm. But remember, intervening means something that came after the defendant acted and before the plaintiff was injured. In this case, the tracks had already been torn up before the driver got there. So, although the torn up tracks were a cause of harm, in the lawsuit against the driver, they were not an intervening cause of the harm. They were what courts sometimes refer to as part of the set stage. They were one of the circumstances that existed when the driver committed his act of negligence. So, when we try to decide whether the driver's negligence, which we know was an actual cause of harm, was a legal cause of harm, we ask the question this way. Given that the tracks were damaged, because they already were when the driver acted, given that the tracks were damaged, was it foreseeable that the driver's failure to look where he was going would lead to a derailment and the injury sustained by this passenger? Was it probable that the driver's failure to look where he was going would lead to a derailment and the injury to this passenger? In retrospect, which means given that the tracks were damaged, is it extraordinary that the driver's negligence, his failure to look, would lead to the derailment and to this plaintiff's injury? In the case of passenger against driver, There isn't any intervening cause. The question is a simple